Your Excellencies, distinguished guests, ladies and gentlemen, we will begin our proceedings shortly. Please return to your designated seats and please switch off your cell phones to silent mode. Thank you.
Your Excellencies, distinguished guests, ladies and gentlemen, please rise. The ceremonial opening of the legal year 2026 now commence. Procession of the court orderlies.
Processions of the Chief Registrar and the Registrars of the courts.
Procession of the members of the Malaysian Bar.
Procession of the State Court Directors.
Procession of the heads of division and deputy heads of division of the Attorney General Chambers. Procession of the President of the Malaysian Bar, President of the Sabah Law Society, President of the Advocates Association of Sarawak. Procession of the Attorney General of Malaysia, Solicitor General of Malaysia, Solicitor General 2, Attorney General for the State of Sarawak, and the Attorney General for the State of Sabah.
Procession of the Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak. The procession is led by the mace bearer carrying the mace, which represents the authority of the Yang di-Pertuan Agong as the fountain of justice delegated to the Malaysian judiciary.
Procession of the judges of the High Court of Malaya and the High Court of Sabah and Sarawak.
Procession of the judges of the Court of Appeal.
Procession of the Honorable Judges of the Federal Court.
Procession of the Right Honorable the Chief Justice of Malaysia, the Right Honorable the President of the Court of Appeal, the Right Honorable the Chief Judge of Malaya, and the Right Honorable the Chief Judge of Sabah and Sarawak. the national anthem, Negaraku. Please take your seats. The Right Honorable the Chief Justice of Malaysia, the Right Honorable the President of the Court of Appeal, the Right Honorable the Chief Judge of Malaya, the Right Honorable the Chief Judge of Sabah and Sarawak, the Honorable Chief Justices and Heads of Foreign Judiciaries, Your Excellencies, Honorable Judges of the Superior Court and Judicial Commissioners, distinguished guests, ladies and gentlemen. To bless our auspicious ceremony this morning, we would like to invite Mr. Ahmad Ashraf Muhammad Kamal, Senior Assistant Registrar, to lead the Dua recital.
Assalamualaikum warahmatullahi wabarakatuh. Let us begin our dua with the recitation of Furqan Al-Fatiha. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Ya Allah, dengan segala kerendahan jiwa kami memohon rahmat dan petunjuk-Mu. Anugerahkanlah kepada kami kebijaksanaan dalam berfikir, kejelasan dalam menentukan arah, serta integriti dalam memikul dan melaksanakan setiap amanah. O Allah, uplift the judiciary and the legal fraternity of this nation as institutions grounded in justice, entrusted with confidence, and held in the highest esteem. Bless this gathering with your mercy and tranquility, and as we depart, grant us your forgiveness, steadfast hearts, and enduring guidance. Rabbana atina fid dunya hasanah, wa fil akhirati hasanah, wa qina adzaban nar. اللهم اختم لنا بحسن الخاتمة ولا تختم علينا يا الله بسوء الخاتمة. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Thank you, Mr. Ashraf.
Honorable judges, Your Excellencies, distinguished guests, ladies and gentlemen, presenting multimedia presentation, Reminiscing Memories of 2025.
honorable judges, your excellencies, distinguished guests, ladies and gentlemen, the Right Honorable the Chief Justice of Malaysia will now preside.
Thank you. I now invite Datuk Yang Berbahagia Datuk Haji Muhammad Azri bin Abdul Wahab, the President of the Malaysian Bar, to deliver his speech.
Assalamualaikum warahmatullahi taala wabarakatuh. Very good morning. May it please your honors, Yang Amat Arif, Datuk Seri Utama Wan Ahmad Farid bin Wan Saleh, the Chief Justice of Malaysia, the Honorable Minister in the Prime Minister's Department, Law and Institutional Reform, Yang Berhormat Datuk Seri Azalina binti Osman Said, Yang Amat Arif, Datuk Abu Bakar bin Jais, the President of Court of Appeal, Yang Amat Arif, Datuk Hashim bin Yahya Hamzah, Chief Judge of Malaya, Yang Amat Arif, Datuk Azizah binti Haji Nawawi, Chief Judge of Sabah and Sarawak, Judges of the Superior Courts and Judicial Commissioners, the Honorable Tan Sri Muhammad Dusuki bin Mokhtar, Attorney General of Malaysia, the Honorable State Attorney General of Sabah, the Honorable State Attorney General of Sarawak, President of the Sabah Law Society, President of the Advocates Association of Sarawak, members of the Malaysian Bar, leaders and members of foreign bar associations and law societies, officials of the Judicial and Legal Service, distinguished guests, members of the legal fraternity, ladies and gentlemen. Yang Amat Arif, my Lord Chief Justice, on behalf of the Malaysian Bar, I wish to record our deep respect for the judiciary and your leadership in safeguarding the administration of justice in Malaysia. Judicial independence remains the cornerstone of the rule of law, and the Bar remains committed to supporting a justice system that is impartial, efficient, and accessible. The cordial and professional relationship between bench and bar is essential to public confidence, and we appreciate the many initiatives taken by the courts to modernize processes and strengthen access to justice. I also take this opportunity to congratulate my Lord as well as Yang Amat Arif, Datuk Abu Bakar bin Jais, President of the Court of Appeal, Yang Amat Arif, Datuk Hashim bin Hamzah, Chief Judge of the High Court of Malaya, Yang Amat Arif, Datuk Haja Azizah binti Haji Nawawi, Chief Judge of the High Court of Sabah and Sarawak, and all judges appointed or elevated in 2025 to the High Court, Court of Appeal, and the Federal Court. The Malaysian Bar has full faith in your appointments. My Lord, I will begin with the cause of celebration in 2025. Malaysia had the honor of chairing ASEAN. For many in Kuala Lumpur and Putrajaya, this first appeared as traffic diversions and road closures, but behind those notices, Malaysia was steering the region with diplomacy and clear purpose. Under the theme of inclusivity and sustainability, Malaysia hosted over 300 ASEAN meetings and guided substantive cooperation across political, economic, and social cultural pillars. A significant milestone was Timor-Leste's formal accession as ASEAN's 11th member state, reflecting Malaysia's commitment to an inclusive region. Malaysia also helped facilitate the Kuala Lumpur Peace Accord between Cambodia and Thailand, demonstrating ASEAN's capacity for constructive diplomacy. Malaysia further championed environmental and sustainability issues, culminating in ASEAN's adoption of the Declaration of the Right to a Safe, Clean, Healthy, and Sustainable Environment, signaling a collective regional commitment to environmental protection and climate exchange. This achievement reminds us that regional leadership must be matched by domestic alignment. To give meaning to such commitments, our national laws must continue to strengthen environmental protection so that principles agreed at the regional level translate into tangible benefits for society. Turning now to recent trends in the legal profession, in today's fast-evolving legal landscape, the practice of law is no longer limited to litigation and courtroom advocacy. Times are changing, and the legal profession must adapt by embracing alternative dispute resolution methods that are effective, efficient, and collaborative. Among these, mediation has emerged a vital tool for resolving conflicts amicably, preserving relationships, and reducing the growing burden on our courts. The Malaysian Bar welcomes and commends the government for its initiative vis-à-vis the international settlement agreements resulting from Mediation Bill 2025. This is a significant and progressive step in strengthening Malaysia's commitment to mediation as a cornerstone of our dispute resolution framework. Central to the Bar's effort is promoting mediation is the Malaysian International Mediation Centre, MIMC. Through MIMC, the Malaysian Bar provides a platform for high-quality professional mediation services domestically and internationally. The centre serves not only as a venue for resolving disputes efficiently, but also as a hub for training, capacity building, and technical support, helping to cultivate a culture of dialogue and collaboration within Malaysia's legal framework. The Malaysian Bar encourages all stakeholders, government, legal professionals, and the public alike to continue supporting mediation as a constructive and forward-looking approach to resolving disputes. By embracing mediation and institutions such as MIMC, we reaffirm our commitment to a legal system that is not only fair and just, but also adaptive, collaborative, and responsive to the needs of the modern society. Pro bono work lies at the very heart of the legal profession's commitment to justice. It embodies the principle that access to legal services should not be determined by one's means, but by the pursuit of fairness, equality, and public good. It is in this spirit that I wish to highlight the My Bar Pro Bono Hub, developed by our Bar Council Human Rights Committee and was launched on December 2025. This platform strengthens access to justice by connecting volunteer law firms with civil society organizations and non-governmental organizations that require legal support for public interest matters. Traditional legal aid systems, though invaluable, cannot always reach every community due to funding constraints, eligibility requirements, or scope limitations. The Hub fills this critical gap by matching vetted cases with experienced lawyers, empowering NGOs and CSOs to seek legal assistance, and promoting strategic litigation that drives systemic change. The Hub focuses on constitutional law, public interest litigation, social justice advocacy, strategic lawsuits against public participation, and strategic litigation on policy and reform issues. It does not handle ordinary criminal defense or personal claims, except where such matters fall within defined human rights criteria and are referred by approved organizations. Each process is transparent, flexible, and open, allowing law firms to register in areas of their expertise and NGOs or CSOs to request support without any means testing. By facilitating meaningful collaboration between the legal profession and civil society, the My Bar Pro Bono Hub embodies the Malaysian Bar's commitment to fostering a culture of pro bono work, advancing access to justice for marginalized communities, and ensuring that public interest causes receive the legal attention they deserve. In partnership with other initiatives, including the Bar Council Legal Aid Centers, the Hub ensures that no one is left behind in the pursuit of justice. I would like to extend my deepest gratitude to everyone who has contributed to this initiative for your vision, dedication, and tireless efforts. It is with great respect and fond remembrance that I dedicate this initiative to the memory of our late Bar Council member, Ravi Chandran Subhaschandran, who passed away on the 11th December 2025. Known for his unwavering commitment to legal aid and pro bono work, his legacy continues to inspire us in our mission to serve the public and uphold the principles of justice. My Lord, there is an old story about the town built beside what everyone believed was a single river. For generations, the people thought the calm waters and the destructive floods come from the same source. Whenever the river overflowed or ran thin, blame was placed on that one river. No one imagined there could be more than one. It was only much later that the elders discovered the truth. There were two rivers running side by side. They were so close that from the surface they looked like one. Yet each carried different strengths, different burdens, and required different rules. One flowed fast and clear from the mountains. The other carried soil and nutrients from the valley. Both sustained the town. Both were indispensable. The confusion arose only because they were treated as identical when in truth they were complementary. That story mirrors the way our legal profession is often understood in Malaysia. We practice within a fused profession. We are admitted as advocates and solicitors under one qualification. By habit and by structure, we treat the river as one, but in reality, there are two distinct streams flowing together. Advocacy demands courage before the bench, clarity of persuasion, and deep sense of responsibility to the court. Being a solicitor demands strategy, commercial understanding, preventive legal work, and risk management that quietly keeps businesses, institutions, and entire sectors functioning. They deserve the same justice system. They serve the same justice system, but they require different skills, different temperaments, and different forms of discipline. When we fail to recognize this distinction, we do more than confuse roles, we diminish value. This misunderstanding has consequences beyond professional identity. It affects how the legal profession itself is perceived by the state and by the society. In Semenanjung, Malaysia alone, the Malaysian bar comprises approximately 25,000 lawyers. This is not a narrow or uniform group. It is one of the largest and most influential professional communities in the country, cutting across wealth, power, ideology, and vocation. Within this body are lawyers who are part of the highest income category in Malaysia, and at the same time, lawyers are running small practices, serving ordinary Malaysians, and carrying the daily responsibility of access to justice. These realities coexist within the same profession, bound by the same admission, the same oath, and the same ethical framework. Members of the Malaysian Bar are not confined to legal practice. Lawyers lead non-governmental organizations and civil society movements. They are deeply involved in policy advocacy, institutional reform, education, human rights, and governance. Many are active in politics, serving in parliament, in Dewan Rakyat and Dewan Negara, contributing directly to the making of laws and national policy. Some members are no longer practicing, yet their impact on the nation is unmistakable. Former lawyers have served as prime ministers, ministers, and deputy ministers. Others sit in legislative assembly, chair statutory bodies, head public institutions, lead major organizations, and preside over boards at national and international levels. The Malaysian Bar has produced presidents of professional bodies, chairpersons of institutions, regulators, policy architects, and strategic thinkers. These outcomes are not accidental. Legal training develops mind that understands structure, consequence, accountability, and the long view of nation building. This is the real composition of the Malaysian Bar, not a pressure group, not a political bloc, not an elite detached from society, but a profession whose members contribute to Malaysia in many different ways across many levels, often without visibility and often without recognition. They facilitate commerce, protect capital, ensure compliance, resolve disputes, and give certainty to those who invest their resources and their trust in this country. When the system works, their contribution is taken for granted. When it fails, the cost is immediate and public. Preventive and advisory legal work, however, can only be sustained when there is a realistic recognition of its value. A system that rewards crisis litigation but undervalues early legal advice ultimately costs businesses more and undermines the long-term viability of the legal practice. Despite this, the legal profession is rarely spoken as an economic contributor. It is seldom framed as part of the nation's growth story. More often, it is treated as a cost, a constraint, or a profession to be controlled rather than developed. That framing matters. Because when the profession is not seen as an asset, it's not invested in as one. This perception has real consequences on the ground. It affects how legal fees are viewed, how professional work is valued, and whether lawyers are paid promptly and fairly for the services they render. For many practitioners, particularly in small and medium firms, the challenge today is prestige. It's not prestige, but sustainability. There is another truth that we must acknowledge candidly. When the Malaysian Bar offers observations or critiques, it does so from a position of professional responsibility and commitment to the long-term stability of our institutions. Constructive dialogue between stakeholders is an important part of strengthening governance and public confidence. Checks and balances are not nuisance, they are stabilizing force. Jurisdictions that command international respect are not those without criticism, but that where criticism is institutionalized and allowed to exist without fear. When concerns are raised early, grounded in law and principle, long-term damage is often avoided. Investors understand this. International observers understand this. Legal certainty does not come from quietness, it comes from credibility. Internationally, Malaysian lawyers are already recognized. They advise on cross-border transactions, appear in international arbitration, contribute to human rights discourse, Islamic finance, maritime law, and emerging commercial fields. They are trusted, competent, and ethical. Malaysia has significant talent within the legal profession. A more deliberate national strategy to develop and project this capacity would position our legal services sector as a regional strength. My lord, the development of legal services also means recognizing and strengthening the full breadth of talent within the profession. In this respect, women lawyers form a significant and rapidly advancing segment of the Malaysian bar. They already lead firms, appear in complex commercial disputes, manage transactions, and contribute to the public policy. To build on this capacity, the Malaysian Bar has introduced the Power Her Leadership, Boardroom and Executive Track for women lawyers. This initiative equips women lawyers with the training and competencies required for senior roles, including board positions, partnership management, and executive leadership. Such roles are strategic in the governance and commercial landscape of the nation. The objective is not symbolic representation, it is to ensure that a profession entrusted with upholding justice is also contributing meaningfully to the nation's economic and institutional development through capable and diverse leadership. Other jurisdictions have made a conscious decision to treat legal services as an expert sector. Adopting similar approaches would allow Malaysia to compete more effectively in emerging commercial fields. If we return to the river, fusion should not mean erasure. It should not mean collapse, advocacy, and solicitorship into a single blurred identity. When we confuse the streams, we weaken both. When we respect their differences, the profession becomes stronger, the courts are better served, and the public benefits. The same is true of the relationship between the profession and the state. There is an opportunity for the government of Malaysia to further recognize the legal profession not only as regulated occupation, but as a strategic partner in governance, economic development, and international positioning. The bar, for its part, must continue to uphold uncompromising standards of competence, ethics, and accountability. Independence must always come with responsibility. Criticism must remain principled, not performative. But partnership requires more than tolerance. It requires trust. It requires an understanding that legal clarity, judicial independence, and professional integrity are not obstacles to growth, but conditions for it. I do not pretend that this relationship is perfect. It is not. There are frustrations on both sides. There are moments of misunderstanding and mistrust. But I stand here with genuine hope that we can do better, that this legal year will be one where the legal profession is not merely heard, but understood, not managed, but valued, not simply tolerated, but trusted. Because a nation that truly believes in the rule of law must also believe in those who uphold it. To conclude, as I stand here for the final time as President of the Malaysian Bar, I'm reminded that this office is never about individual who holds it. It is about the trust placed in the institution and the duty to honor that trust with clarity, honesty, and restraint. The voice of the Malaysian Bar has weight, not because of who speaks it, but because it has long served as a compass in moments when directions is uncertain. For that reason, our positions must always be rooted in integrity and a genuine commitment to the future. As I conclude, I ask those entrusted with power in any sphere to pause and put aside the rivalries, disappointments, or personal grievances that can cloud even the best intentions. These things corrode quietly, and the cost is borne not by us alone, but by those who will inherit the country we shaped today. Let us channel our energy towards building a Malaysia that gives our children a steadier path, a clearer system, a fairer chance, a Malaysia where justice is not an aspiration, but a lived reality. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Thank you, Dato' Haji Muhammad Ezri. I now invite the Honorable Mr. Attorney General Tan Sri Muhammad Dusuki bin Mokhtar to deliver his speech. Dipersilakan.
May it please Your Honours, the Right Honourable, the Chief Justice of Malaysia, the Right Honourable, the President of the Court of Appeal, the Right Honourable, the Chief Justice of the High Court of Malaya, the Right Honourable, the Chief Judge of the High Court of Sabah and Sarawak, the Honourable Chief Justices and Heads of Foreign Judiciaries, the Honourable Minister in the Prime Minister's Department, Your Excellencies, Honourable Judges of the Superior Courts and Judicial Commissioners, distinguished guests, ladies and gentlemen, Assalamualaikum warahmatullahi ta'ala wabarakatuh. A very good morning, warm greetings, and Salam Malaysia Madani. Ya Ma'arif, Ya Arif, ladies and gentlemen, allow me to begin by expressing my utmost and sincere appreciation to the Malaysian judiciary. I am honored to be here this morning. My deepest appreciation to Ya Ma'arif, Chief Justice of Malaysia, for this opportunity to share my thoughts in this respected gathering. It is a privilege I do not take lightly, and I am grateful for Your Lordship's confidence and gracious invitation. On this beautiful day, it's not too late for me to offer my heartfelt congratulations to Yang Ma'arif, Datuk Seri Utama Wan Mat Farid bin Wan Saleh on the appointment as the Chief Justice of Malaysia, Yang Ma'arif Datuk Abu Bakar bin Jais on the appointment as the President Court of Appeal, Yang Ma'arif Datuk Hashim bin Hamzah on the appointment as the Chief Judge of the High Court of Malaya, and Yang Ma'arif Datuk Hajah Azizah binti Haji Nawawi on the appointment as the Chief Judge of Sabah and Sarawak. We eagerly look forward to benefiting from Yang Arif's wisdom and guidance. Yang Arif, ladies and gentlemen, in January 2023, the Prime Minister Yang Berhormat Datuk Seri Anwar bin Ibrahim introduced the Malaysia Madani Framework. The Madani government has called for a paradigm shift, one that emphasizes values, accountability, governance, reform, sustainability, and inclusion. For Attorney General's Chambers, or AGC, this is not merely a policy direction. It is a responsibility and a duty to the nation. AGC remains firmly committed to advancing this vision through principled, diligent, and people-centered service. Last year, AGC received first place in the Best Kampung Angkat Madani Award for the Kampung Angkat located in Kampung Jelit 8 dan Rangkaian Mungkin Bujang, Kuala Muda, Kedah at the Majlis Simposium Pembangunan dan Anugerah Pembangunan Negara 2025. It was the highest recognition and an inspiring achievement reflecting the dedication of officers and the foresight of Yang Arif Tan Sri Ahmad Teriruddin bin Muhammad Saleh, our former Attorney General, in spearheading community-centered initiatives. As 2026 begins, we renew our commitment to the Madani government with clear purpose and unity. Yang Arif, ladies and gentlemen, AGC serves as the central legal authority of the government, exercising a comprehensive mandate in shaping, guiding, and implementing legal reform initiatives. In fulfilling its constitutional and statutory responsibilities, AGC undertakes vigorous legal analysis, conducts systematic reviews of existing legislative frameworks, and oversees the drafting, vetting, and harmonization of new legislation to ensure full compliance with the Federal Constitution. To meet emerging national needs and strengthen the rule of law, AGC has contributed significantly to the enactment of numerous important legislation in 2025, including the enactment of the Parliamentary Service Act 2025, the Consumer Credit Bill 2025, the Cross-Border Insolvency Bill 2025, Legal Aid and Public Defense Bill 2025, Gig Workers Bill 2025, and Government Procurement Bill 25, to name a few. One of the most significant reforms undertaken is the separation of the roles of the Attorney General and the Public Prosecutor. On 10th September 2025, the Cabinet agreed to adopt a full separation model with both offices held by different individuals of equal status. The Cabinet also endorsed the tabling of the Federal Constitution Amendment Bill in the 2026 Parliament session. To implement the recent Cabinet decision, AGC has reactivated the Working Committee and several subcommittees which have been set up since 2018 to refine the detailed proposals on organizational structure, staffing, logistic, financial consideration, and phase implementation strategies. Yang Arif, ladies and gentlemen, AGC remains committed to ensuring that all Malaysian laws stay relevant and up to date. In line with this commitment and in exercising the revision powers conferred by the Revision of Laws Act 1968, we have cumulatively revised 295 pre-1969 federal law, reflecting our sustained efforts to safeguard and bolster the nation's legal framework. In 2025, AGC has revived a total of 12 laws, including 2 principal legislation. AGC has also undertaken to reprint the Federal Constitution in both English and the national language text with the consent of the Yang di-Pertuan Agong pursuant to Article 160A of the Federal Constitution. Subsequently, we have also reprinted 39 acts and subsidiary legislation at the request of various ministries. Additionally, AGC has translated 12 pre-1967 laws into the national language, particularly for the purpose of prescribing the text in the national language as the authoritative text under the National Language Act. This function may seem administrative, but they strengthen the backbone of our legal system in ensuring clarity, accuracy, and public access. Yang Ma'arif, ladies and gentlemen, as part of the Madani government's reform agenda, AGC has also been instrumental in advancing key child protection statutes such as the Sexual Offences Against Children Act 2017 and the Evidence of Child Witnesses Act 2007, both of which significantly strengthen the protection, participation, and evidentiary rights of children in justice system. To make this endeavor a reality, AGC works closely with the Legal Affairs Division of the Prime Minister's Department under the visionary and decisive leadership of Yang Berhormat Datuk Sri Azalina binti Osman Said, our Honorable Minister in the Prime Minister's Department, Law and Institutional Reform, who has played such a major role in this reform agenda in coordinating policy, prioritizing legislative initiatives, and synchronizing efforts across agencies. This move demonstrates the commitment of the Madani government towards a broader legal reform agenda. This collaboration ensures that proposed amendments and new bills proceed in alignment with national policy directions, cabinet parameters, and legislative government processes. We also work in partnership with the judicial and enforcement bodies in supporting the strengthening of courtroom procedures involving children by providing legal input for the development of child-sensitive mechanisms. This encompasses advising on the use of intermediaries, providing separate waiting areas, establishing controlled courtroom environments, and facilitating alternative modes of giving evidence. Such measures minimize trauma for child victims and witnesses, ensuring that judicial and enforcement procedures affecting children are applied consistently, sensitively, and in a manner that upholds their rights and welfare. Case in point, AGC plays a key role in the formulation of the anti-bully bill by undertaking direct legal drafting, refining statutory definitions, and ensuring consistency with related legislation such as the Penal Code, the Child Act 2001, the CPC, the Sexual Offences Against Children Act, and the Evidence of Child Witnesses Act. Beyond advising on the legal implication of policy decisions, AGC prepares and drafts legislative text that articulates clear duties, responsibilities, and safeguarding obligation for schools, institutions, and enforcement bodies. The anti-bully bill is designed to address both individuals and systemic forms of bullying, including bullying that is embedded within our supported by institutional system, rules, or culture, and encompasses bullying occurring in physical, digital, and educational institutional environments. AGC also contributes to evaluating the implementation and effectiveness of recent amendments and reforms relating to child protection and anti-bullying. This includes identifying enforcement gaps, recommending legislative or policy improvements, and ensuring that Malaysia's legal framework remains responsive to contemporary challenges while adhering to international best practices in child protection. AGC also collaborated with the National Legal Academy to design and deliver specialized training modules on child protection laws, child-sensitive procedures, and trauma-informed approaches. By leading legal drafting, constitutional assessment, prosecutorial guidelines, and coordination across agencies, AGC plays an essential role in driving child protection and anti-bullying reforms that are legally sound, aligned with national policies, and consistent with Malaysia's overall priorities. We shall strive to ensure that the legal system adapts effectively to evolving societal demands and modern challenges, thereby enhancing institutional transparency, strengthening accountability, protecting vulnerable communities, and upholding the rule of law. Yang Ma'arif, ladies and gentlemen, AGC plays a vital role in representing Malaysia on the international stage, safeguarding our national interests while upholding the principle of justice, fairness, and the rule of law. Certain contributions and efforts to promote and strengthen justice and the laws are stated forthwith. In April 2025, the AGC team led by Datuk Seri Solicitor General II participated in the ICJ hearings on Israel's obligation relating to the occupied Palestinian territory. Malaysia reaffirmed its long-standing position on the Palestinian right to self-determination and highlighted Israel's breaches of international law. The joint statement by ASEAN law ministers on the development of international commercial arbitration and mediation have been adopted at the ASEAN Law Forum, which was held in August 2025. The joint statement aims to further strengthen regional commitment to legal reform, the establishment of shared standards, and enhanced cooperation, reflecting ASEAN's collective vision to reinforce the foundation of the rule of law to support economic resilience and regional unity. In this regard, AGC was involved directly in preparing the joint statement. AGC officers also participated in the 24th ASEAN Senior Law Officers Meeting and the 30th ASEAN Law Ministers Meeting in Manila in November 2025, where Malaysia signed the ASEAN Treaty on Extradition, a milestone after more than 20 years of negotiation. Apart from that, Malaysia also hosted the 47th ASEAN Summit in October 2025, during which Timor-Leste's admission into ASEAN was formalized through two documents, namely the Declaration on the Admission of Timor-Leste to ASEAN and the Instrument of Accession of Timor-Leste to the ASEAN Charter. AGC was involved to ensure that both documents were in order before this historic event was finalized at the recent 47th ASEAN Summit in Kuala Lumpur. Yang Arif, ladies and gentlemen, in today's global economy, trade agreements are no longer just economic documents, they are legal framework that determine investment flows, employment opportunities, and long-term national competitiveness. In 2025 alone, AGC participated in 18 free trade agreement negotiations, contributing legal expertise to ensure Malaysia's rights and obligations are clearly safeguarded. 4 major agreements were successfully concluded. The Malaysia-Korea Free Trade Agreement, the Malaysia's EFTA Economic Partnership Agreement, the Malaysia-United Arab Emirates Comprehensive Economic Partnership Agreement, and lastly, the ASEAN-China Free Trade Area 3.0. In line with the National Energy Transition Roadmap, Malaysia is advancing its commitments under the United Nations Framework Convention on Climate Change, the Paris Agreement, and the Kyoto Protocol, particularly through legal frameworks supporting carbon capture and clean energy. Toward this end, Malaysia has enacted the Carbon Capture, Utilization and Storage Act 2035 and the Carbon Capture, Utilization and Storage Offshore Permit and Licensing Regulation 2035. AGC officers have given full commitment in realizing the first comprehensive national legal framework for the entire CCUS value chain in the South ASEAN region, positioning Malaysia as a potential regional carbon management hub. Yang Arif, ladies and gentlemen, in line with the Madani paradigm shift, AGC will continue to evolve and improve the laws to strengthen governance and to serve Malaysia with dignity and excellence. As we open the legal year 2026, let us affirm our pledge to uphold justice, not as a privilege, but as a right for every Malaysian. The strength of our nation lies not only in the laws it enacts, but in its courage to enforce them fairly and without fear of ever. Allow me to share a brief pantun or pantun in Bahasa Malaysia. In English, we call it pantun. To reinforce this call. Banyak sungguh bunga melati, bawa mari ke dalam pekan. Hidup kita lawan mati, mana jahat kita tinggalkan. For the foreign dignitaries, I would like to translate that we should leave the bad deeds behind and let us move forward. That's the rationale of this pantun or pantun, Yang Arif, ladies and gentlemen. To conclude, as guardians of the rule of law, we bear the responsibility to ensure that justice is accessible, impartial, and effective. With dedication and unity, we can build a justice system that truly serves the people fairly, transparently, and without compromise. I would like to recite from the Al-Quran, Surah An-Nisa, verse 135, which reminds us, O you who have believed, be persistently standing firm in justice, witnesses for Allah, even if it be against yourself or parents and relatives. Whether one is rich or poor, Allah is more worthy of both. So follow not personal inclination, lest you not be just. And if you distort your testimony or refuse to give it, then indeed Allah is ever of what you do aware. With that, I would like to record my gratitude, and I wish everyone a meaningful and rewarding year ahead. Assalamualaikum warahmatullahi ta'ala wabarakatuh. And thank you.
Assalamualaikum warahmatullahi wabarakatuh, and a very good morning. My brother and sister judges, Your Excellencies, distinguished guests, ladies and gentlemen. Marilah kita sama-sama menzahirkan kesyukuran kepada Allah Subhanahu wa Ta'ala kerana dengan kurnia dan izinnya dapat kita bersama-sama hadir pada hari ini bagi majlis pembukaan tahun perundangan 2026. Distinguished guests, ladies and gentlemen, as we gather this morning for the opening of the legal year 2026, I would like to wish each and every one of you a very happy new year. On behalf of the Malaysian judiciary, I extend my sincere appreciation to all of you for honoring us with your presence at this annual landmark event. I thank the Attorney General and the President of the Malaysian Bar for their preceding speeches. The President of the Malaysian Bar talks about the tale of the two rivers, while the Attorney General speaks of the paradigm shift. On this occasion, allow me to also extend my heartfelt congratulations to the Right Honourable Justice Datuk Abu Bakar Jais on his Lordship's appointment as the President of the Court of Appeal, the Right Honourable Justice Datuk Hashim Hamzah as the Chief Judge of Malaya, and the Right Honourable Justice Datuk Haja Azizah Nawawi as the Chief Judge of Sabah and Sarawak. To each and every newly elevated judge of the Federal Court, Court of Appeal, High Court and Judicial Commissioners, you now carry not only authority, but expectations. I hope that you serve with distinction, compassion, and integrity to this institution and the nation. To the former Chief Justice, Tun Tengku Mahmud, Tuan Mat, former President of the Court of Appeal, Tan Sri Dato' Amar Abang Iskandar bin Abang Hashim, former Chief Judge of Malaya, Tan Sri Hasnah Muhammad Hashim, former Chief Judge of Sabah and Sarawak, Tan Sri Abdul Rahman Sebli, and all judges who retired in 2025, thank you. Those two words seem inadequate for what you have contributed, but they come from all of us with deep sincerity. Thank you for the years you dedicated to upholding justice, for the countless hours spent carefully considering evidence, weighing arguments, and crafting decisions that would stand the test of time. Sitting here today, I am deeply conscious of both the privilege and the responsibility of this moment, as it marks my first opening of the legal year as the Chief Justice. Before I proceed further, I wish to place on record the judiciary's sincere appreciation to His Majesty the Yang di-Pertuan Agong and the Government of Malaysia for the implementation of the 30% salary increment, which has taken effect this month. This measure is both timely and significant. It is worth noting that this is the first adjustment in a decade since the last revision. Judges do not receive annual increments and are precluded from holding other offices or engaging in business. Seen in this context, This increment reflects a clear recognition of the demands placed upon judicial office and a meaningful commitment to strengthening the welfare of the judiciaries in support of a resilient, credible, and high-performing administration of justice. The increment is, in my opinion, contributes to promote the independence of the judiciary. To my fellow brother and sister judges, enhanced remuneration must go hand in hand with heightened responsibility. Judicial office carries with it the expectation that judges will read extensively, remain abreast of legal and societal developments, equip themselves with new knowledge, and never cease learning. In a rapidly evolving legal landscape, continuous learning is not a choice, it is a duty. Let me reiterate that a fairly compensated judiciary serves as an important safeguard, helping to shield judges from undue influence, encouraging capable legal minds to step forward in service, and in allowing those who sit on the bench to discharge their duties without undue financial concern. In my first 100 days in office, I have indicated my intention to explore the possibility of introducing performance-based incentives for the Superior Court judges who demonstrate diligence, discipline, and sustained commitment to the timely discharge of their judicial duties. This practice is nothing new. It is adopted in certain comparable jurisdictions, including Singapore, and it is one that merits careful and principled consideration. Access to justice from principle to reality. The theme of access to justice invites us to ask an honest question. Are our systems serving the people effectively? While the pathways to resolving legal disputes may differ, true access to justice is characterized by independence, efficiency, accessibility, and responsiveness. Justice must not remain a distant ideal. It must be a lived reality. As the Chief Justice, one of my guiding philosophies is this: the constitutional spirit embedded in our federal constitution must be reflected not only in our judgments, but also in the way we conduct ourselves as an institution. Access to justice is now further enhanced with the following initiatives. Circuit sittings initiatives. On the 27th of November 2025, we revived the Court of Appeal circuit sittings, with its first sitting held in Penang. This year, inshallah, we are planning to further expand this initiative to Kuala Terengganu, Johor Bahru, Miri, and Tawau, as well as holding federal court sitting in Kuantan High Court. The significance of this development is twofold. First, it ensures that access to justice is no longer confined geographically. Second, to create opportunity for professional growth within the legal community, especially for young and aspiring advocates. In my maiden speech, I pledged my commitment to improving the standard of advocacy among the young lawyers. As we all know, that appellate work has traditionally been concentrated in Putrajaya, a situation which limits exposure for young practitioners or chambering students living outside of Klang Valley. By bringing the appellate hearings closer to regional bars, our circuit sittings initiative further advances the cause of equal access to justice and opportunity, and is not constrained by geographical factors. Mobile courts. The mobile courts of Mahkamah Bergerak initiative is one that the judiciary holds close to its heart. It is not merely a program of convenience, but a reaffirmation of a simple belief that justice must reach those who have long found it furthest away. It was born out of necessity to serve communities in remote and interior areas where traveling to a courthouse was often an insurmountable challenge, and in places where no permanent court buildings existed. These courts attend to applications for late registration of birth certificates, provide services of commissioners for oaths, and facilitate the attestation of documents, with plans to expand the program to Peninsular Malaysia. In May 2025, the Children's Mobile Court Initiative was launched with 3 key components: the Vehicle for Meaningful Redress, VMR, to safely transport child victims and witnesses; the Victims Nexus to Justice, VNEJ, a child-friendly mobile facility where children can give testimony remotely in a comfortable environment; and the Vehicle for Nationwide Justice, VNJ, a fully equipped mobile courtroom. The VNEJ is specially designed with daybeds, pillows, books, toys, and anatomical dolls to help children express themselves comfortably while giving evidence. Particularly in cases under the Sexual Offences Act against children, trained victim liaison officers, VLO, support children throughout the process with care and compassion. I'm proud to share that this initiative has received international recognition. When I spoke at the International Conference on Justice in Riyadh last year, our mobile court program was recognized by the global legal community as among the best practices in the world. In cases involving sexual offenses against minors, we take care of the witness every step of the way, from their home throughout the journey and into courtroom. For the current year, the judiciary wishes to record its sincere appreciation to the government for the allocation of 5 million ringgit, which will enable the procurement of 15 additional VNEJ units for deployment across the states. This support from government through the Minister of Law and Institutional Reform is deeply appreciated. Through initiatives such as these, of which we are grateful, access to justice is not merely promised, but meaningfully realized. New court buildings. Beyond policies and plans, access to justice is often shaped by something very tangible, whether there is a courthouse within the reach of the community. In 2025, the Pengerang Court Complex was successfully completed and is now fully operational. Similarly, in Kinabatangan, Sabah, a new court has been constructed to better meet the needs of the local population. Prior to 2009, residents of Kinabatangan were required to travel all the way to the Sandakan Court merely to file applications, as there was no court facility in the district. Looking more broadly at our national development agenda, under the 12th Malaysia Plan, the general approach has been to prioritize the replacement of older, worn-out court buildings so that judicial services remain safe and fit for purpose. This includes the Johor Bahru Court Complex and the Sikh Court. In addition, a new court in Nilai will be constructed, marking the first court to be built there. On that note, a new Shah Alam Court Complex is long overdue and should be seriously considered. In Sarawak, progress continues steadily. The Mukah Court has completed renovation works to enable its relocation from a building shared with the state government to a rented premises, with operations expected to commence this year. At the same time, construction of the new Sri Aman Court is scheduled to begin this year, with completion targeted for May 2029. Meanwhile, in Sabah, I'm pleased to share that the new Tenom Court will be launched next week. This relocation was both necessary and long overdue, as the previous premises were old, stuffy, and uncomfortable, with frequent electricity disruptions. Looking ahead, Sabah's development plan further includes the rollout of the new Sipitang Court this year. Through these efforts, I remain hopeful and that all identified projects will be completed in a timely manner. Distinguished guests, ladies and gentlemen, the Judicial Blueprint, a decade of purposeful reform. Allow me to move to the second theme of my speech, the Judicial Blueprint, a 10-year comprehensive reform plan that encompasses, among others, strengthening the rule of law, access to justice, transparency, institutional development, judicial efficiency, administration of justice, judicial leadership, the standard of advocacy, especially among the young lawyers, and governance. While the tenure of any Chief Justice is necessarily finite, The reforms we set in motion must endure. It is my hope that the judicial blueprint I'm about to announce will leave a lasting and a meaningful imprint on the administration of justice. The blueprint adopts the multi-door approach to the delivery of justice, rule of law, and capacity building. Promoting the rule of law is at the heart of the work of the judiciary. Sustaining and improving the capacity of courts and courts administrations is one practical aspect of maintaining the rule of law. In tandem with this theme, our Judicial Academy, established under the Judicial Appointments Commission, JAC, serves as the powerhouse of judicial excellence. I'm pleased to announce that on 22nd of August 2025, the Cabinet had approved the proposal to establish a dedicated and structured Judicial Academy. I wish to record my deepest appreciation to the government, in particular to the Right Honourable Prime Minister and the Minister in charge of Law and Institutional Reform, for the strong and unwavering support extended in ensuring the establishment of a dedicated and structured Judicial Academy is brought to fruition. With the establishment of the Academy, the JAC is now in the final stage of obtaining approval for staffing positions and temporary premises before it can operate officially, which I anticipate will be towards the end of the first quarter of this year. Writing judgments is part and parcel of the judge craft. Our duty to give reasons for our decisions ensures that parties, especially those who are dissatisfied with the outcome, are able to understand why they won or lost their case. Where appropriate, they can exercise their right of appeal. I understand and I listen to the frustration of litigants who may wish to file an appeal, only to discover that the decision was delivered long ago, but the written judgments are often not ready within the stipulated time frame of 8 weeks. To address this, the Academy will first take a paternalistic approach of understanding the challenges faced by the judges rather than penalizing them. Having said that, I'm aware of the increasing number of unwritten grounds of judgment of the High Courts. The former Lord President, Tun Sofyan, once remarked, a judge's duty is to dispense justice without fear or favor. I would add that we must also dispense it without undue delay. A judge who carries a backlog of 10 or more outstanding grounds of judgment is carrying a heavy burden, not just for the system, but on their own conscience. You know who you are. We will do everything in our power to assist those who are struggling, but we must be honest. There is a limit to existence. The bench is a place for those who can stand the heat of the fire. I have to be fair to the litigants. I have to be fair to the Court of Appeal judges who cannot proceed with the appeal just because the grounds of our high courts are not available. For the sake of the public who await our decisions, we cannot allow the machinery of justice to be clogged. To put it bluntly, and I rarely say this, the kitchen is open, but the service must be timely. If the heat is no longer to your liking, the exit remains a dignified option. Justice begins with well-being. The Honourable Andrew Bell, Chief Justice of New South Wales, once observed, and I quote, "The single greatest source of stress and pressure on the judiciary is the volume of work expected to be discharged by the state's judicial officers," unquote. Those words resonate deeply with the experience of many within our judiciary, not only judges of the superior courts, but also the lower courts and judicial officers at every level who carry day after day the responsibility of deciding matters that affect lives, liberties, and livelihoods. We are entrusted with immense responsibility, long hours, emotionally demanding cases, complex legal questions, and a constant expectation of fairness and composure form part of our daily reality. These demands do not diminish with seniority, nor are they lighter in the lower courts, where caseloads are often heavier and the pace unrelenting. Over time, this burden can accumulate often unseen and rarely spoken about. Judicial well-being, therefore, is not a peripheral concern. It goes to the very core of who we are as judges and judicial officers, and to the quality of justice we are entrusted to deliver. Judicial well-being is an essential foundation of judicial independence, integrity, and sound decision-making. The Nauru Declaration of Judicial Well-being reminds us that the health and well-being of judges is inseparable from the quality of justice delivered to the public. It is for this reason that the judiciary has formed a Judicial Well-being Committee. And we must also remember this. Justice is never delivered by judges alone. Our judicial officers, registrars, and court staff stand alongside us every day, often under the same pressures and constraints. Their well-being is equally vital to the administration of justice. When those who serve the courts feel supported and valued, the entire system becomes stronger, more humane, and more resilient. In caring with one another, we safeguard not only ourselves, but the integrity of the justice entrusted to us. Technological innovation. The judiciary began its journey towards the adoption of computing technology and digitalization as early as 2009, with the aim of ensuring that filing, registration, management, and hearing of cases could be carried out in a more orderly, efficient, and systematic manner. The court's digital delivery system, known as e-Kehakiman, is accessible and usable by all stakeholders, including members of the public. Taking into account the success that the system has now been in operation for more than a decade, the government has agreed to further develop, enhance, and upgrade the existing platform, and has approved the e-Kehakiman Phase 3 project for the 3-year period from 2025 to 2028. Furthermore, in line with the government's aspiration to develop and deploy artificial intelligence, AI, within public administration, the judiciary is fully engaged in this project to study and explore the suitability of AI in case management, court proceedings, and judicial workflows. I hope that the relevant stakeholders will be able to develop AI solutions that are both appropriate and responsible to assist the judiciary in expediting the delivery of justice. The secret of AI is prompt engineering, asking the right question to get the right answer. I realize that that's exactly what I've been doing for the past 10 years on the bench. The only difference is that when I prompt a lawyer, I don't get a response in 2 seconds. I usually get a request for an adjournment to next Tuesday. It is in this spirit that I assure the bar that the AI will never replace judicial wisdom, mostly because an algorithm cannot yet understand the nuances of a witness's nervous cough or his body language. The appointment of judges, a pressing institutional imperative. As of today, the strength of the Superior Court stands at 147 judges, comprising 14 Federal Court judges, 27 Court of Appeal judges, 68 High Court judges, and 38 Judicial Commissioners. At the subordinate court level, the administration of justice rests on 165 Sessions Court judges and 170 magistrates, bringing the total number of Sessions Court and judges and magistrates to 335. While these figures may appear substantial in isolation, they must be assessed against the sheer volume and complexity of cases flowing through the courts. The lower courts, in particular, serve as the first and primary point of contact for the public with the justice system. It is at this level that burden of rising case registrations is most immediately and intensely felt. Malaysia's continued economic development, socio-economic transformation, and evolving societal dynamics have led to a significant and sustained increase in case filings across all court levels. This growth has had a direct and cumulative impact on judicial workload, not only for judges of the superior courts, but especially so for judicial officers serving at the lower courts, who handle high-volume dockets and under intense time pressure on a daily basis. The statistics are telling. Between 2021 and November 2025, criminal registrations rose from 1.5 million to 2.4 million cases, representing an increase of 63.3%. Civil case registrations increased from 303,000 to 483,000 cases, an increase of 59.54% over the same period. These figures reflect a structural trend rather than a temporary surge. Looking at it positively, a more litigious society is a society that has faith in its judiciary. Despite these mounting pressures, judges and judicial officers at all levels continue to discharge their duties with professionalism, diligence, and commitment, trying their level best to ensure that cases are resolved within prescribed timelines. However, it must be said with candor that efficiency cannot be sustained indefinitely without commensurate institutional support. There is a natural limit to how much additional workload can be absorbed without affecting well-being and quality of decision-making. This challenge is further underscored when viewed in comparative perspective. Malaysia currently has one Superior Court judge for approximately 239,000 people, serving a population of about 36 million. Australia, by contrast, Australia has roughly one Superior Court judge for every 124,000 people, while Canada has approximately one judge for every 40,000 people. These jurisdictions maintain significantly higher judicial density, enabling faster case resolution and more sustainable workloads. The implications are clear. The current shortfall in judicial manpower, both at the superior and subordinate court levels, places immense and growing pressure on the justice system. In particular, the limited number of established posts or perjawatan for judicial officers has resulted in heavy caseloads for sessions court judges and magistrates, contributing to delays and uneven workload distribution across states and districts. For these reasons, there is an urgent and pressing need for the government to consider increasing the number of perjawatan of judicial officers, especially those serving in the lower courts. Strengthening manpower at this level is not merely an administrative adjustment, it is a critical intervention to ensure that access to justice remains timely, effective, and meaningful for the public. For the Superior Court judges, as part of our broader action plan, JAC is reviewing proposals for additional appointment of judges and judicial commissioners and to suggest possible amendments to the Federal Constitution if the need arises. In addition, we are also exploring the appointment of highly specialized practitioners as judges on a contractual basis and the establishment of the stand-alone commercial court building in Kuala Lumpur with the aim of strengthening judicial capacity in complex commercial matters. Building confidence in commercial justice. I'm pleased to announce that this year, the judiciary will establish the International Commercial and Admiralty Division, ICAD, at the High Court of Kuala Lumpur. The establishment reflects a direction I consider both timely and necessary. I'm aware that for businesses and investors, confidence in the court plays a real and practical role in deciding where to invest and how disputes are resolved. Through ICAD, I intend to place greater emphasis on the effective management and expeditious disposal of commercial cases involving multinational and international companies. To me, this is a practical response to changing commercial realities. It is about ensuring that our courts remain relevant responsive, and able to meet the expectations of those who place their trust in our justice system. If parties can be assured that their disputes will be managed fairly and efficiently, it strengthens confidence in Kuala Lumpur as a place to do business and to resolve disputes. These initiatives, taken together, are intended to relieve systemic pressure, enhance judicial efficiency, and reinforce confidence, both domestically and internationally, in Malaysia's administration of justice. Law reform. Law reform is an integral pillar of the judicial blueprint, underpinning our efforts to ensure that the law remains responsive, coherent, and aligned to the needs of a modern society. Meaningful law reform forms an integral component of the judicial blueprint, serving not only to improve legal clarity and consistency, but also to strengthen public confidence in the justice system. Among my plan under law reform is to address the backlog of family cases. To address this, we are exploring statutory measures to expand the jurisdiction of the Sessions Court judges to hear additional family court matters beyond joint petitions. This measure aims to increase judicial capacity to handle more complicated family matters in the High Court, which in turn improves the delivery system of family justice. Establishment of a committee to study the mechanisms for regulating the registration of new cases in the superior courts and subordinate courts in Malaysia. Moving on would be the establishment of this committee in early November last year, with the Right Honourable Justice Dato' Abu Bakar bin Jais, President of the Court of Appeal, serving as its advisor. The committee is expected to recommend steps that help balance judicial workload and improve the effectiveness of the administration of justice. The key problem identified is that case filings are rising, but the number of judges are barely changed, creating an imbalance of workload capacity. The study also flags judicial well-being, warning that sustained pressure can lead to fatigue, stress, and burnout, which can affect the judiciary as a whole. The scope of study includes identifying ways to control new case registrations, which may involve reviewing jurisdiction limits, reviewing the threshold for leave to appeal, expanding mandatory ADR, such as mediation, improving case filtering before registration, and strengthening pre-trial case management, PTCM. It also includes a full study of judicial workload and workload imbalance across all court levels, supported by collecting and analyzing statistics and survey data, plus any further appropriate study work. The committee will conduct an extensive study based on surveys and on-the-ground insights, and will take place in 2 phases. In the first phase, we aim to have the interim research report by June this year. As to the second phase, we'll finalize our findings by July next year. Way forward. As we look ahead, we will continue to refine and strengthen the judicial blueprint, guided by a clear commitment to ensure that no one is left behind in our pursuit of justice. What I have shared today is only the beginning. Much of this is work in progress, shaped by careful study, consultation, and reflection. Nevertheless, the judicial blueprint does not stand alone. At the operational level, the Strategic Plan 2026 to 2030 of the Chief Registrar's Office also serves as its practical counterpart. While the judicial blueprint sets the long-term direction, the strategic plan translates that vision into concrete and measurable initiatives. By implementing these blueprints, judicial reforms with unwavering commitment, we plant the foundations for regaining World Bank recognition in the rule of law and justice sector performance. The institutional strengthening, transparency mechanisms, and accountability frameworks we establish today, especially so post-COVID-19, will yield the international credibility we once enjoyed. As we sow these principles of judicial excellence, so shall we reap the World Bank's renewed confidence in our legal system once more. Distinguished guests, ladies and gentlemen, the quiet bone of justice, legal research and judicial excellence. Turning now to legal research and judicial excellence. Legal research is not a mere preliminary step. It is the backbone of sound judicial reasoning, particularly in the preparation of grounds of judgment. Behind every carefully reasoned decision lies hours of meticulous work, examining statutes, tracing precedents, analyzing comparative jurisprudence, and reconciling competing legal principles. It is therefore no coincidence that in established judiciaries such as those in the United Kingdom, United States, and Singapore, judges place significant reliance on law clerks or justices' law clerks, whose primary responsibility is to support this intensive research process. Their contribution, while seldom visible, is indispensable to the delivery of justice. They are, in short, the unsung heroes. Under our current arrangement, we have judicial clerks within our in-house judicial clerkship program. They are stationed at the research division of the Chief Justice's office. These judicial clerks are employed under the Malaysia Short-Term Employment Program, MITEC, for a one-year period. At the conclusion of their contracts, they may choose to apply for the judicial and legal service as L9 grade legal officers or to pursue careers in private practice. Regrettably, many of them, though brilliant, do not remain beyond their short-term appointments. Limited remuneration and uncertain career prospects have led many to continue their professional journeys elsewhere. In response, I have commissioned a proposal to elevate the status of judicial clerks to L9 legal officers on a 2-year contract basis, with corresponding remuneration and allowances. This initiative is not simply about financial recognition. More importantly, it reflects our acknowledgement that legal research is a cornerstone of judicial excellence, and those who shoulder this demanding responsibility deserve proper institutional support. The proposal has now been submitted to the relevant government agency and is presently under review. We remain hopeful that this initiative will receive the government support as part of our shared commitment to strengthening the judiciary. The bench, the AGC, and the bar, the chariots of justice. An independent judiciary cannot exist in isolation. We do not operate in silos. We operate within a constitutional ecosystem in which the AGC and the bar each play indispensable and distinct roles. While our functions differ, we are united by a shared commitment to the rule of law and the fair administration of justice. Judges, by long-standing convention, do not respond to public commands or criticism. We speak through our written judgments. The AGC, as a principal legal advisor to the government, plays a critical role in ensuring that matters brought before the courts are presented with professionalism, integrity, and respect for legal process. The bar, in turn, represents the voice of the litigants and the conscience of the legal advocacy without fear or favor. Together, these three institutions, the bench, the AGC, and the bar, form the pillars upon which public confidence in the justice systems rests. Under my leadership, I am committed to fostering constructive and principled engagement with the AGC and the bar. Judges benefit from the assistance of well-prepared submissions and principled advocacy, just as prosecutors and counsel benefit from clear, reasoned judgments. This professional dialogue, conducted within proper constitutional boundaries, strengthens the quality of justice delivered. At this juncture, I pause to ponder on the story of the two rivers told to us by the President of the Malaysian Bar a moment ago. I have just returned from a short break in Bangkok, where a substantial portion of this speech is written. I remember standing by the banks of the Menam Chao Phraya last week, watching that ancient river flow with such quiet, unstoppable force. I was reminded of the nature of justice. A river does not ask for permission to flow. It simply flows its course carving its way to the landscape regardless of the obstacles placed in its path. Judges are human. Behind the rope, some of us get tired. And yes, we even sigh when faced with the 100-page written submissions, only to realize that the main points are in the last 2 pages. And to add fuel to the fire, when Council takes us on a scenic tour to the Swiss Alps and the Black Forest, before finally arriving at the crux of the matter in the train of oral submissions. Yet, we must remain calm and composed to maintain court decorum. Looking ahead, I'm mindful that no blueprint, howsoever ambitious, can implement itself. Meaningful reform requires cooperation, goodwill, and sustained commitment from all stakeholders. The successful implementation of the initiatives outlined in this address depends on the collective efforts of the judges, the AGC, and the bar, judicial officers, court staff, as well as the executive and the legislature. Distinguished guests, ladies and gentlemen, collaboration beyond borders, international cooperation, international judicial cooperation. In an increasingly interconnected world, the administration of justice can no longer be viewed through a purely domestic lens. Legal issues today, whether in commercial disputes, family matters, insolvency, or the protection of vulnerable persons, often transcend national borders. Against this backdrop, the judiciary remains firmly committed to strengthening international judicial cooperation, guided by mutual respect, shared values, and a common dedication to the rule of law. Our closest and most developed judicial partnership is with Singapore. Through a series of letters of exchange between successive Chief Justices, both judiciaries have reaffirmed their commitment to sustained and meaningful engagement. These commitments have paved the way cooperation in specialized areas of law, which include cross-border corporate insolvency and family justice. I'm pleased to note that Malaysia will host the inaugural annual judicial exchange in family justice later this year. Beyond Singapore, we continue to strengthen ties with the region and beyond. With Brunei Darussalam, a memorandum of judicial cooperation signed in March 2024 has already borne fruit through judicial lecture series and attachment for Bruneian judicial officers. Our engagements with the state of Qatar and Turkey promote exchanges of experience, judicial training, dialogue on developments in civil procedural law, and exchange of best practices. In my recent meeting in Riyadh with His Excellency Dr. Najim Al Zaid, the Vice Minister of Justice of the Kingdom of Saudi Arabia, we have agreed to improve bilateral judicial cooperations. We also value our long-standing engagement with England and Wales. I'm pleased to inform that we have specialized training programs hosted by the Judicial College of England and Wales in 2025, focusing on sexual offences against children, trafficking in persons, vulnerable witnesses, judgment writing, case management, and judicial well-being. These programs, conducted in close collaboration with the UK Ministry of Justice and the British High Commission, have enriched our judicial capacity perspective. Council of ASEAN Chief Justices. Since my appointment as the Chief Justice, I've had the privilege of engaging closely with our ASEAN judicial family, including my participation in the 12th meeting of the Council of ASEAN Chief Justices, CACJ, held in Singapore last year. At the end of the meeting, we resolved on several key initiatives for future collaboration and development. To strengthen our regional legal fabric, we are simplifying how ASEAN court orders are authenticated and enforced. We are also prioritizing the human dignity through new trafficking in persons protocols and mandating specialized training for the growing challenge of climate change litigation. The Working Group on Judicial Education and Training will also continue preparations for the ASEAN Judicial Fellows Program. To prove Malaysia's continuous commitment to the future endeavors of CACJ, I'm proud to announce that Malaysia will host the CACJ Working Week this year, and I look forward to warmly welcome all delegates to Malaysia. ASEAN Law Association. While the judiciary's engagement through the CACJ remains a central pillar of our regional cooperation, I would also like to take a moment to personally acknowledge the important role played by the ASEAN Law Association, the KUALA. The KUALA provides a valued platform that brings together judges, members of the bar, legal academics, and policymakers from across ASEAN to exchange ideas, share experiences, and learn from one another. Last year, KUALA Malaysia had the privilege of hosting the KUALA inaugural lecture entitled Gender Justice and Legal Pluralism in ASEAN. This occasion also marked the establishment of the KUALA Standing Committee for Women in Law. Distinguished guests, ladies and gentlemen, reflections on the path ahead. Come August marks the first year of my tenure as 17th Chief Justice of Malaysia. I accept this responsibility with humility and deep sense of responsibility. I firmly believe that our people are our greatest asset, the human capital. If we were to deliver justice effectively, we must ensure that our institution is supported by adequate human resources and a culture that genuinely values its people. To this end, our judges, judicial officers, court staff must never feel undervalued, overstretched, or unappreciated. Their well-being and morale are essential to the quality of justice we deliver. To all judicial officers and court staff, to all the directors of court in the states, I speak from the bottom of my heart. During my state visits last year, I visited all the states. I witnessed firsthand of your dedication, professionalism, and quiet perseverance. Your contributions often go unseen, but they are deeply felt. Each of you deserves recognition and sincere appreciation. You are the backbone of our legal system. You are the wheel that drives the judiciary forward with purpose and momentum. Without your commitment, our judicial initiatives would remain mere plans on paper, blueprints gathering dust. I also wish to express my sincere appreciation to the AGC, the Malaysian Bar, and all legal stakeholders for your continued support and constructive engagement. May our Silatur Rahim continue to flourish, grounded in mutual respect and a shared commitment to justice. My brother and sister judges, let us continue to serve with courage, wisdom, and integrity. Let us not fail those who place their trust in us. On my way to this magnificent conference center this morning, I could not help but glance at the Menara Merdeka 118, the second tallest building and structure in the world, only behind Burj Khalifa in Dubai. If the Chaupraya represents the flow of justice, Merdeka 118 represents its stature. Like that imposing building, the independence of our judiciary must be towering. It must be the first thing a citizen sees when they look for protection, and the last thing that yields the storms of political pressure. It does not lean, it does not waver, and it certainly does not apologize for its height. Remember, justice does not announce itself, it simply arrives. Before I close, allow me to share a short reply to Tan Sri AG's pantun. Or pantun. Bawa bunga ke dalam pekan, jemput penghulu untuk makan. Mana yang jahat kita tinggalkan, mana yang adil kita tegakkan. Once again, I wish each and every one of you a happy new year. May the year 2026 bring you good health, renewed purpose, and abundant opportunities. Thank you very much.
Thank you to the Right Honorable the Chief Justice of Malaysia. Honorable Judges, Your Excellencies, distinguished guests, ladies and gentlemen, we have now come to the end of the proceeding. The Malaysian judiciary extends its deepest gratitude to all parties who have made this proceeding a success. Your Excellencies, distinguished guests, ladies and gentlemen, please remain in your position until the announcements to leave the hall is made. Please rise.
Announcing the departure of the Right Honorable the Chief Justice of Malaysia, the Right Honorable the President of the Court of Appeal, the Right Honorable the Chief Judge of Malaya, the Right Honorable the Chief Judge of Sabah and Sarawak, and the Honorable Judges of the Federal Court.
Your Excellencies and distinguished guests seated at the front row. Honorable Judges of the Court of Appeal,
Honorable Judges of the High Court of Malaya and the High Court of Sabah and Sarawak.
Honorable Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak.
The Chief Registrar and Registrars of Courts. The Court Orderlies.
Ladies and gentlemen, you are now cordially invited for lunch at Hall 5, Level 2. Thank you.